matters that were dealt with extensively in the sixth administration, and I think those that were still or were leading the department, Minister, they would have said that there was extensive briefing from the Minister and work that was done by the department in terms of consultation on the white paper. And our understanding is that it has gone through the executive process, including cabinet approval, and other issues that are left is to develop a bill that must be brought before Parliament so that we are able to interact with members of the public and stakeholders to further comment so that we deliberate and have an intensive discussion in Parliament. This is an important piece of legislation once considered by Parliament. And also to deal with the matter that resides on Vulindlela recommendation in relation to the work of Home Affairs. And I think there are identified areas which have been raised and the work that has been done by the collective led by the former Director General of Home Affairs. Minister and Deputy Minister, listen carefully during the security cluster comments or responses on the intention of the department to, and I'll state deliberately, you will interact when we comment, to bring the bill in the year 2027. And I think it's a concern that we may need to register that given the urgency and the challenges that the country is facing, including security issues, and also the economic impact that may contribute to the delay of this bill that as a result of the white paper. It will be important that this committee, as we deliberate, and yourself consciously, you must note that concern that one has observed in our discussion. I think it's an important area that we may need to collectively, both as the members of Parliament and ourselves as the department, fast track this process. I've also gone through the Vulindlela recommendation in relation to this matter. And I'm fully aware that there may be other issues that may need to arise to the white paper, which may need to go through the same process which yourself, you are aware in terms of cabinet subcommittee and cabinet. But as we are now, we are clearer in terms of the process that we must develop a bill that may need to be considered by Parliament. We're not going to waste time, given the challenges that we're facing as a country, to delay the work of the department, including the white paper. So I'm just trying to highlight key issues that we'll be confronted with as a committee and the collective. And this is an area that we've interacted with the former minister and the team in the year 2020 in terms of the declaration of this white paper. We are happy that Cabinet has now considered the white paper. I'm in particular on the time frame and the period that we may need to agree on. Without waste of time, I will then invite, I will suggest that the program on how we're going to deal with it, members. One is that we'll request the department to deal with 2 items at once. Item number 3 and item number 5. Then we'll comment both the white paper briefing and the Vulindlela, then we'll comment on questions. And then we'll deal with the update of the provincial public hearing and the details, and also the briefing on the 3rd program of the committee. And then we'll then adopt the minutes. Is the proposal accepted, members? Okay, thank you very much, and welcome other members who have not been in the meeting. I think the first time we interact together, but are those that have been seasoned in Parliament, so we are familiar with our our interaction. I will just take this advantage to introduce Mr. Matonsi, just introduce members who are not been with us so that they are familiar with the collective of the team.
Morning, members. We do have members, new members. Reverend Mishwe is not a new member, as the Chief has indicated, but also it's the first time him attending this meeting. That's Reverend Mishwe here on my right-hand side. And then there is Mr. Hala. Also, yeah. That's all, Chair.
Thank you. Is there any apologies? We must register.
Yes, Chair, we do have two apologies. One from Ms. Mohamed. She indicated that she was not feeling well. Then the other one is Ms. Ntolo. She just landed at the airport at 9:30, so she will be here at any time. Thanks, that's all from my side.
Minister, any apologies? We must register.
No, Chair, I think we've got a full house.
Thank you very much. We'll now invite the Minister to introduce, or delegates to introduce, the two presentations. All apologies have been recorded. Then we'll interact on responses and comments, and members will have enough time to deal with the presentation.
Thank you very much, Honourable Chair, Honourable Members. Good morning also to those members that are joining us in this committee today for the first time. And also good morning to the DM and the team from the Home Affairs Department. Chair, you will know that I am very much able to introduce, but I think we're starting to become very familiar with each other in this committee. So I think what I would like to just very briefly touch on before I hand over to the team is maybe just a high-level view on both of these items, if I may. Because I would like to express my gratitude to the Chair and to the committee for actually scheduling these ones on the same day, because it's going to illustrate the interplay that actually exists between these two processes. So I would urge members to look at these things as connected, because they are dealing essentially with the same space. And that space really involves the high-level view on the immigration system, citizenship and refugee protection that comes from the white paper, first of all. The process, Chair, is correct, as you've outlined, that this went through Cabinet in April, and at one of the subsequent meetings, the minutes also served, and you could see that there were quite a number of points that were raised in that Cabinet discussion, and pointers that were given to the department to say, go and refine this, go and add in this space. So we've got that as one of the major inputs on the white paper that we will then need to process to go forward with into the bill. I think the other important input, of course, is from Operation Vulindlela itself, and that's where the interplay will become clear, where we have the opportunity to supplement some of this work through making sure that the legal changes actually align with what the President and the administration have put on the table. I think one thing that's very important, Chair, to caution against is we should not have a misalignment between what the Presidency and this department is doing in terms of modernizing Home Affairs and reframing our systems and the white paper itself. And so I think that even as we move into this space, it's important to get it right at the start, because what we don't want is a bill that comes to this committee and then we've got the Presidency, for example, saying to us, but this is misaligned with the work that Vulindlela is doing. So the supplementation process flows out of the need to make sure that we have really concrete and correct alignment on these issues. There's also a legal opinion that we have commissioned on the white paper to make sure that we are covered and really comply with the injunction we've got in the statement of intent as well of the government, that we must always make sure that we align with the Constitution. And I think that's an important point, actually, Chair, as we deal with international matters. Our primary injunction here is to comply with the South African Constitution. There's all kinds of international spaces out there, but I think we need to check our policy and legislation always against what our constitution itself demands. And so it's in that space that we will also then get that opinion. So, Chair, essentially we will then move as fast as humanly possible, we've heard you there, to supplement and make sure that the priorities of the 7th administration, the work of Operation Vulindlela, the legal opinions are all commissioned and aligned so that we have the best product at the end of the day. I also want to emphasize, Chair, that this is an enormous scope that we're talking about. I would liken it to major reforms in health, for example, or education. It's actually at the same scale. And so it is absolutely critical that we get it right, that we don't have a process that gets thrown out in court, because that will actually be the worst outcome we can imagine, because then we'll be worse off than we are today. So we need to make sure that, given the scale of this is not like the marriage bill, with all due respect. This is not like the immigration amendment bill that we're dealing with. This is a complete systems relook. And so we have to pay close attention to detail and make sure we get it completely aligned. Then, Chair, I think the other point worth making is on Operation Vulindlela itself. And you will see from the presentation that there are elements in that work that will require regulatory change, first of all, but then also feed into legal changes and legislation. I must say, Chair, I'm very excited about the opportunities we've got through the work that we're doing with Operation Vulindlela. I think the DG will attest that we're moving with real speed to give effect to this priority that is really one of those cross-cutting opportunities we have in government, because what we see with Vulindlela is the ability for us to bring together views from different departments and make sure that when we talk about unlocking the skills that the country needs, for example, unlocking tourism, that we're able to actually do that and create jobs and economic growth in the process. That is really the apex priority of this administration. And so we believe we've got a very strong contribution to make in this space. Just to give you a sense, Chair, the trusted tour operator scheme that that the department will elaborate on, it's got the potential to unlock the Chinese market, for example, as well as the Indian market. A country like Australia is getting about 1.4 million Chinese tourists a year. We're getting about 93,000. Now, there is no reason why anyone would go to Australia if they could come to South Africa. And what we've identified there is the bottlenecks that are created, sometimes through very basic things. I mean, Mandarin documents that we cannot interpret or understand. So it gets into that kind of granular detail where we then say, also because these Chinese, they travel in large tour groups, so you'll get 100 or 200 applications at once. And we need to just rethink how we deal with that. And so that's where we've come up with a trusted tour operator scheme, which will vet and secure the tour operator and say, if you bring someone here who overstays or breaks the law, you will actually bear the consequences. So then we are able to process those group applications more effectively. And I really believe if we can get this off the ground, we will see a major impact in terms of boosting tourism in a relatively short period of time. So that's an example of where Vulindlela has real opportunities in the immediate term. But then, of course, Chair, we need to make sure that if Vulindlela is saying to us, this is one of the reforms we need in the tourism space, that we actually have it enabled in the legislation. And that's where you can see the link between the two and why it's so important that we have that supplementation process to make sure that we actually align with those kind of priorities. So, Chair, that's a mouthful, but I would invite, if I may, the DG to take over from here and fill us in on the details and really highlight, I think, some of the exciting opportunities we've got in this space. Thank you very much.
Thank you. There's one matter, Mr. Matuns. I think there are some members who are requesting a link for this meeting. If you can just pay attention to it on the group of the... I was assisted by the Deputy Minister that this meeting is physical. I thought when I landed, I just trying to reach my place. So I think Mr. Matun seems Adam, can you deal with that logistics so that we don't account to members? It's a serious matter. DJ?
Good morning, Chair, and good morning, honorable members. Good morning, Minister, Deputy Minister. Maybe just to indicate that the team, for those that might not be familiar with the team from Home Affairs, on my extreme right, it's DDG Thomas Sigama, is responsible for civic services, which means your IDs, passports, birth, marriages, and so on and so forth are with them. And then acting DDG, Mr. Matthews, immigration services, visa-related queries, law enforcement. And at the back, it's Mr. Yusuf Simons, who will take members through the presentation on Operation Vulindlela, the implementation thereof. He's the PM for the Western Cape Provincial Manager, but he's also project manager on Operation Vulindlela. And then on my immediate left, it's DDG Tulani Mabuso, who's responsible for operations. Will take us through the white paper on citizenship, immigration, and refugee protection. And at the back, Advocate Pelelani Kumalo, head of our legal services. Next to him, it's Sihle, responsible for policy. I think towards my immediate right at the back, Kayagazi from the DM's office, and Dwayne Isao from the Minister's office, the spokesperson, and then Mosi, and then Smamisa as well from the DM's office. I think I'm missing Advocate Gao, sitting behind Reverend Michelle, yes, is the PLO for the Minister. So for the first presentation, Chairperson, Mr. Mabuso will take you through this presentation, but what we wanted to highlight is really the following. Firstly, it's the key policy and legislative reforms that are currently underway. But in addition to that, also to highlight that there's a number of priorities that the presidency is leading on, including issues around digital transformation. And to that extent, they've set up an intergovernmental team that is working around issues on digital transformation. And of course, we need to take that into consideration. And the second one is the milestones that we've traversed over a period of time on the white paper on citizenship, immigration, and refugee protection. And then he will also give you an overview of the white paper. But critically, it's key policy recommendations. And thereafter, a minister spoke about the medium-term development plan priorities. There are 3 priorities that have been identified, and the team will be able to take you through those. And then, of course, we have to align ourselves with that. And then the next one will be on Operation Vulindlela. The minister did indicate that there were 8 policy recommendations that were made. 4, of course, are legislative, and the other 4, it's process or systems. We have been able to implement 7 out of 8 of those. We're just finalizing the last part, which is more on the technology, and the others we have implemented. But critical is the fact that in the State of the Nation address, the President also spoke about further visa reforms. And to that extent, the Presidency appointed a team called the Genesis to look at what else can we do to do exactly what the Minister was referring to. How do we bring in more tourists? And that team is working on a number of options that at some point will come back and indicate what is it that we're doing with regards to that. So over to Mr. Mabuso through you, Chair. Thank you.
Thank you, DG. Thanks, Chairperson, Minister, and honorable members. So as DG and Minister have indicated, the purpose therefore today was to take the portfolio committee just to note the process, and as DG has indicated, the number of areas that I'm not going to speak. So the process in relation to the white paper, Chair, I just want to take the members just one step back to say that when we conceptualized the white paper on citizenship, immigration, and refugee protection, it was because in the past, Cabinet had approved a white paper on international migration. But owing to a number of developments that see people who carry certain immigration documents like visas, permanent residence, that creates also a pathway to citizenship. So it was therefore imperative that we look at actually creating a legislation that covers all those three areas, because you also have refugees who qualify for citizenship at some point. So therefore the issue of dealing with one legislation and repealing all the others was quite important. So we just highlight here the base documents that we utilized, including that cabinet approved international white paper on international migration in 2017 and the other legislation that are relevant to that. We went through a process of the green paper in 2021-22 where we had a lot of extensive consultation. We went to various clusters in government, and also obviously as DG has indicated in the 2 previous financial years, there was a ministerial report on the issuance of visas and permits that was highlighting a number of areas that we needed improvement. And then the minister's comment on the issue of Operation Vulindlela, that led to the revision of the white paper. And then in the previous financial year, we had to go undertake a process of public consultation across the country with various stakeholders. The recent one, which we did also early this year, was the workshop on international migration with mayors and traditional leaders, which was held in Boksburg. So some of the key policy and legislative reform, I think Minister has made an indication on that. I'm not going to repeat on the issues relating to Vulindlela, and also the introduction of the remote work visa and startup visas and the trusted employer scheme, and also one of the key areas around the issue of enhancing the travel into South Africa is the creation of the electronic travel authorization in order to enhance the visa. Most countries doing that. For an example, the UK, they do that for certain countries. If South Africa, for example, we've got a number of countries that are visa exempt. So meaning that if we were to introduce an electronic travel authorization, in other words, we're giving a notification ahead of time who to expect, even though they don't have to bring a visa, but the fact that they actually notified in terms of that electronic travel authorization. When we look at the UK, for example, they also charge about £10, for somebody to apply for that. Then the next one is around the one-stop border post policy. This white paper has already been approved. There are certain obvious components of the policy that require legislation to be passed, but also there are those that allow us to start engaging with neighboring countries in terms of creating a process to establish common zones, common control zones in the one-stop border post, and also the OSPP has since been tabled in Parliament after Cabinet passed it last December. And Chair, I think this one on immigration amendment, we have been dealing with the issue of Section 34(1)B and D, which obviously was declared unconstitutional by the court. So again, that has since been tabled in Parliament. So all of these, obviously, are current policy and legislative reforms that are currently underway that need to be taken into consideration, as the Minister indicated, that this gives rise to the amendment to a certain part of the policy in order for us to draft the legislation. So at a high level, Chair, I'm not going to deal with some of the specifics, because we thought we should just summarize the issues that are coming out of white paper without being exhaustive, but just to indicate the context within which this white paper was developed, and that it was approved, obviously, by Cabinet, as Minister has indicated. There were a number of consultations that I've also made reference to. But also, Chair, just to emphasize the point, as the Minister did indicate, that the complexity of this is at a high level. So therefore, issues around constitutionality become very important, so that you don't create a legislation or policy that will be not be in line with our Constitution. So there are a few policy positions that are contained in the white paper, which will just at high level again talk about those particular areas. Chairs have indicated on citizenship, the major policy reform that we are dealing with is that the white paper recommends that the Citizenship Act, Birth and Registration Act must be repealed and be included in single legislation dealing with citizenship, immigration and refugee protection, in order to remove some of the contradictions in the path towards citizenship. So that's one area. And the second one was around the criteria for granting of citizenship needs to be reviewed. Other countries obviously have developed a restrictive naturalization approach, so limiting those who contribute, limiting to those who contribute to the economic development of the country. In this instance, ours was more of an academic exercise, of an administrative progression, that you get work visa or study visa, you move to a PR, you move to citizenship, sometimes attracting people who are not contributing positively to the country. Because also what this leads into, pressure on social protection, where, for example, the countries ought to provide, whether is it old age social protection grants and other related. So those resources being constrained, therefore creates huge challenges to the country. That is why ours is to say those who are contributing positive in terms of critical skills, therefore they're quite important. Chair, this slide just shows the current types of visas that we currently have, which we refer to obviously under the Immigration Act. Then we've got functional services, which are temporary waivers, and then the categories of PR. This is on the right-hand side, Chair, just to show permanent residents that there are those that we get through Section 11(6), general work, criticals, and so forth, and also the sort of what one would regard as permits under the Refugee Act, which is asylum seeker visa and the refugee permit. So as Minister has indicated, we need to obviously align with some of the changes that the Genesis report is talking about, in order for us to ensure that we either scrap certain types of visas and also or improve some of them and introduce some of the new visas like the remote work visa. So as we review these, the new ones obviously will be coming on board, and then we'll be removing obviously those that we believe that they are not making economic contribution into the country. So the first part that we are raising as a major policy reform is that the number of years that a foreign national has resided in the country will no longer be a main determining factor for granting permanent residence. Periodic invitations for qualifying foreigners to apply for permanent residence will be introduced together with a point-based system. Then the policy framework also affirms the use of critical skills lists to attract international migrants with skills and qualifications that are in demand. I think this is quite an important area. Also, the introduction of a limited duration permanent resident permits linked to obviously minimum investment. And also the policy framework must provide for the establishment of the Immigration Advisory Board that will advise the Minister on policy and legislative matters. In the current legislation, there is a provision for Immigration Advisory Board, but we are saying that that must not be lost, because I think how it was constituted previously and what the Minister's vision is to be able to attract the kind of individuals that will be able to have the required expertise to be able to help us to deal with these issues, and also at a distance, at the arm's length, and be able to advise looking at what international practices are. But also the policy framework also legislation requires that an establishment of immigration courts, chairperson, this will obviously be a matter that we'll have to deal with together with the Department of Justice, because I think if you look at the issues relating to immigration, the issue of interpretation of some of the legislation in relation to immigration, there's been a number of challenges that we have had. For an example, when the Section 34 was declared unconstitutional, one of the issues was that if people are arrested for deportation, we need to first to get a confirmation from the magistrate. So that created huge challenges in terms of the courts. At some point, magistrates were not willing to help in that regard. So if you're dealing with immigration court, therefore, you are able to create a space that they are specifically for that particular area. Obviously, that comes with some of the costs that will be associated with that. Then the last part on this section is in around the Border Management Authority. We are saying that when we look at some of these policy reforms that we are proposing, obviously they will impact on the BMA legislation, so we will need to just review it to align with the new policy reforms. Chair, this slide, we just brought it in just to demonstrate that under refugee protection, it's just to demonstrate the trends that we have had. In 1998, when the legislation was enacted, the South Africa registered about 11,135 asylum seekers who applied for refugee status. And again, that number kept on continuing until the 2008 economic meltdown, where that number actually went up to over 200,000 in 2008 and 2009. when we saw a huge migration to the south because of economic meltdown. And interestingly, when you look at this number, a majority of the people who applied for asylum during that period, and actually across the years, the approval rate of asylum seekers as confirmed refugees, it's sitting just below 6%. So about 94% of all those who claim asylum, actually those cases are found to be maliciously unfounded or abusive claims, so to say. So what then happened in this period, which I always want to give context around people when you look at people who are carrying asylum papers, is that the legislation at the time required that the Refugee Appeals Board, which is currently now called the Refugees Appeal Authority, at the time the legislation was saying members of the board need to sit as a quorum to hear an appeal, meaning that if you have 5 members of the Refugee Appeals Board, they must sit as so 3 of them must hear one matter. Now, if you're sitting with over 200,000 matters or applications for refugee status after the first process by a status determination officer has been exhausted, the Standing Committee on Refugee Affairs has confirmed that this application is maliciously unfounded and abusive, then the person goes to the Refugee Appeals Board. So meaning that if members were to hear 20 cases a day, it will mean that in a week, which is 5 days, they will probably hear only 100. So meaning that that backlog kept on continuing. Hence, these people who were claiming asylum, they kept on then renewing their asylum seeker permit every 6 months, leading to some obvious staying for up to 10 years in the country. And then also in the process, they have children, they have businesses. By the time a person matter gets here and is thrown out, the person is now going to raise another claim around the interest of the child and many other related matters. So that is why we are saying in the new legislation, we need to look at the convention to ensure that when South Africa entered the 1951 convention relating to status of refugees, we entered it without reservations. So we are saying South Africa must therefore consider the inclusion of the reservations in the convention and the 1967 protocols relating to refugees, status of refugees. But that must be done again in line with our constitution to ensure that we don't shoot ourselves in the foot by actually taking certain reservations that will be found to be unconstitutional. So that's a point that I think the minister is also trying to emphasize. So the new legislation also must enable the country to refuse the admissions of persons for whom there's reasonable grounds for regarding as a danger to the security of the country. Again, we have had cases where people who have committed atrocities in the countries of origin, coming, claiming asylum, and South Africa being seen as protecting fugitives, international fugitives that are wanted by what we call international law enforcement. So we work obviously cooperatively with Interpol and other agencies to ensure that such individuals. So we're saying that we need to be able to reject such asylum on the basis of that. The interesting issue, other chairperson that we want to, and members that we also want to look into, is the introduction of the first safe country principle as a precondition for admitting asylum seekers who have transited through safe countries. I mean, we receive asylum seekers from thousands and thousands of kilometers away and who have passed certain countries. Some will fly to certain countries connecting to South Africa and then they claim asylum. So that's become an important issue to say that are we dealing with genuine asylum seekers in this instance, or is just a question of economic migrants utilizing a particular route to legalize themselves in South Africa? Those are some of the critical areas that we need to look into. Chair, there's a trend that we've also been seeing is that when somebody is illegal in the country, when they are being arrested for transgressing immigration laws, then they claim asylum. So we're saying asylum seekers in that instance must show good cause for their unlawful entry and presence in the country before we can deal with that particular matter. So I think it's quite an important area also that we need to look at. The last 2 points, Chair, is around refugee reception offices that must be located at the ports of entry in line with international practice. Because in many countries, if somebody comes to the port of entry, they claim asylum, the matter is processed there because the refugee reception office is at the port of entry. Fortunately with us, we only have one refugee reception office that is closer to a port of entry in Musina. The rest of the inland, in Pretoria, in Cape Town, in Gqeberha, in Durban. So most of those are processed close by. Well, with those coastal towns also, do not receive much asylum seekers that come through harbors, but we receive mainly, or seaports, we receive mainly through airports and also land ports. So those are some of the areas that we need to look into. And then also, we also need to reconfigure and capacitate our refugee status determinations and appeal structures in line with, again, international practice to ensure that the type of people that you appoint as refugee status determination office, some of them are legally qualified to be able to deal with those particular matters. And then to ensure that, obviously, the appeal processes, again, we don't want to trample on the Constitution, because in terms of PAJA, as we issue out administrative decisions, we need to be able also to give reasons around. That's why the Administrative Justice Act compels us to be able to do that. So, Chair, as I conclude, therefore, it's just indicating that as a department, we have identified areas that require further strengthening of the approved white paper, and also to look at the Government of National Unity priorities, the medium development plan, and also the Operation Vulindlela report and Genesis. This obvious necessitates that we improve this particular white paper. So we are currently working on the supplementary policy paper that will be submitted to the Minister by end of this current financial year. So, as I said, the supplementary paper will also take into consideration the legal opinion which has been commissioned by the department. And also, Chair, we had tabled in front of the committee and Parliament in March this year an annual performance plan that has performance target, including to this area of developing a bill for citizenship, immigration and refugee bill. And therefore, it will mean that we are going to be reviewing this particular target in line with a provision that has been made to all government departments that they can actually review their 24-25 annual performance plan to take into consideration the priorities that have emerged out of the 7th administration. So that is currently being undertaken and will be retabled back to Parliament before the end of October 2024. Thank you very much, Chair. That concludes our presentation.
Thank you.